The Supreme Court Constitution Bench comprising Chief Justice of India UU Lalit, Justices Dinesh Maheshwari, S. Ravinder Bhatt, Bela M. Trivedi and J.B. Pardiwala on Thursday continued hearing a batch of petitions challenging the constitutional validity of the 10% quota in educational institutions and government jobs for economically weaker sections of citizens, popularly known as the EWS reservation. The arguments yesterday were commenced by Solicitor General of India Tushar Mehta, who had provided a brief framework of its arguments in the last hearings. For those of you who are unaware of the issue, back in January 12, 2019, the Union government had brought about a constitutional amendment to Articles 15 and 16 of the Constitution, which deal with the right to equality and reservations. Prior to this, there were provisions for seats and jobs to be reserved for the scheduled castes, scheduled tribes, and socially and educationally backward classes. Thus, pursuant to this particular amendment, the government introduced a 10% reservation for general category citizens who are economically weaker. The central government has defined economically weaker sections as those with an annual family income of less than Rs 8 lakh. Subsequently, several petitions were filed in the Supreme Court of India challenging this constitutional amendment on the ground that it violates the basic structure of the Constitution. We have made a detailed video on the arguments that were advanced during the prior hearings, the link to which has been given in the description box below. Please do check it out. Let us now see what are the arguments that were advanced in the Supreme Court yesterday. Solicitor General Tushar Mehta commenced his arguments by submitting that constitutional amendments could be challenged only on the ground of violation of the basic structure of the Constitution, that is the foundational feature of the Constitution that cannot be amended. He stated that while challenging statutory provision, it was permissible to state that a given provision violates an article of the Constitution. However, he pointed out when the Parliament itself inserted a provision, the validity of such a provision could not be questioned unless the provision shook the very identity of the Constitution. He elaborated further that the Constitution is not static and that it can take care of the aspirations of the nation. He stated that if the Parliament feels that some affirmative action is required without disturbing the basic structure of the Constitution, then the court cannot interfere in such circumstances. Enumerating further on how to identify as to what constitutes the basic structure of the Constitution, the Solicitor General stated that the principle in this regard was that it must not violate the preamble of the Constitution. Referring to the 103rd Amendment, he stated that the amendment in fact strengthens the preamble by extending economic justice, which is a fundamental part of the preamble. On the point of what constitutes a violation of the basic structure, S.G. Mehta quoted Justice Sikri from the Keshavananda Bharti vs. State of Kerala judgment of the Supreme Court and stated that it's like the four legs of a chair. Unless you remove one leg and it stops being a chair, it's not to be struck down. He further referred to the Supreme Court's judgment in Minerva Mills vs. Union of India case to argue, and I quote, "It should completely change the identity if they wish to scrutinize the constitutional amendment. Basic features are in general constitutional rules, but only those which are central to the Constitution. Identifying basic features isn't by identifying best features, but the central features." However, Justice Bhatt was not satisfied with this line of argumentation and questioned as to how even newly amended features of the Constitution can violate the basic structure. Justice Bhatt remarked during the hearing, and I quote here, "You can't trace even federalism in preamble, yet it is in basic structure." In Minerva Mill, the amendment had sought to undo Keshavananda. So the court went back to basic structure and said you cannot transcend the amending power. The point is, even newly amended features can violate basic structure. Right to education, earlier it was a directive principle and now it is a fundamental right. Article 265 says no one can be taxed without authority. It's not fundamental right, but it is important. If you delete it, would it not violate basic structure? In response, the Solicitor General stated that the amendment had only introduced an enabling provision, so states were not mandated to but permitted to introduce EWS quotas. He, however, agreed with the CGI in that the basic structure theory being ever evolving, and further stated that the petitioners have the burden of showing that there is an absolute prohibition of economic criteria in the Equality Code, that is in Articles 14 to 18 of the Constitution, and only then will it amount to the amendment violating the basic structure. He also argued that the petitioners have to show that the 50% reservation is invoidable. The Solicitor General also emphasized that the amendment treats poor people as a class and is flexible and does not violate the basic structure of the Constitution. Highlighting that economic criteria can be a determinant of backwardness, the Solicitor General argued, and I quote here, "We have broadly 50% of reservations, 50% of non-reservation. The 10% are again general category, open category students. In civil services, more than 50% are below yearly income of 2.5 lakhs. Per family is just rupees 20,000. This is where substantive equality comes. You equalize them with others. That is justice economically and as expected in the preamble." He further added that something which was flexible could never be basic structure and highlighted that reservations went up to 70% in some states. At this juncture, Justice Bhatt pointed out that it is not as if the people belonging to the EWS quota do not have any identifiers at all, as they all belong to some caste, and thus this amendment contains a negative connotation, which is that one should not belong to a particular caste. Justice Bhatt further remarked during the hearing, and I quote here, "When it comes to economic criteria, there is no identification. There are 25 states. They can come up with any criteria. There is indeterminability. You call it flexibility, but it's indeterminability. You might enact something, but the point is that basic controlling provision EWS is not capable of control by Constitution." When S.G. Mehta retorted by saying that social backwardness was also not defined in Article 15 Clause 4 of the Constitution, Justice Bhatt pointed out that the definition of social backwardness, one had to go beyond the Constitution to the preamble, speeches of Dr. Ambedkar, debates in the Constituent Assembly, etc. Pertinently, Justice Bhatt underscored that while economic backwardness can be temporary, other forms of backwardness is attached to lineage and therefore transcends generations. He remarked, and I quote here, "When it is about other reservations, it is attached to lineage. That backwardness is not something which is not temporary, but goes down to centuries and generations. But economic backwardness can be temporary." The Solicitor General then pointed out that the 8 lakh figure, which is a determinant of the EWS quota, has been arrived at after a detailed study of parameters. He elucidated further, and I quote, "Earlier, a person having a telephone was not poor, but today a person with a telephone can be poor. Further, absence of guidelines is not a ground for challenging amendment. It's not basic structure, it is curable. The government can come out with a commission. If without that exercise some state implements EWS, that executive act can be challenged." S.G. Mehta also contended that the 50% limit was a thumb rule and not sacrosanct. Thus, it could not be elevated to the level of basic structure. He stated that there existed two kinds of judgments on this issue. The ones which stated that the 50% rule should not be ordinarily accepted, and the other category which stated that the 50% ceiling limit was merely a thumb rule and not an invoidable rule. He also pointed out that the scheduled caste and scheduled tribe communities, as well as the socially and economically backward classes, can avail existing reservations and that they already have protection, unlike the economically weaker sections. However, at this point, Justice Bhatt questioned this line of argumentation and pointed out, and I quote here, Is it right for an egalitarian government to say that sorry, you are the poorest of poor, but you have exhausted your reservation? I am not looking at totality, I am looking at the individual. The constitution has to have meaning to an individual. Argument of collective goes on, but it breaks down at individuals. We are looking at the impact on equality. If you're an SC or ST of a particular state, you have a right. The moment you move out, your choice to move out debars you from claiming the SC/ST status. There it is an individual choice, here there is no choice. Chief Justice UU Lalit also added that compared to economically weaker sections in the scheduled tribe and scheduled caste categories, those economically weaker sections people in the general categories are far better off. With this, the bench adjourned the hearing to coming Tuesday. Thank you. This is Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates. If you like our content, please do not forget to like and subscribe to our YouTube channel.